normally I would say the names of the parties. I'm not sure how to pronounce ABBT.
Abbt.
Abbt. All right. You may proceed.
May it please the court. Subject to the court's questions, I'll be focusing my opening argument time on Ms. Abbtt's hostile work environment claim. Although this case involves modern facts, this court and the Supreme Court's long-standing precedent squarely applies and requires reversal. Ms. Abbtt's two superiors, one of whom was a district chief, secretly and repeatedly watched an intimate video that she had made for her husband. This video had been stored on a personal laptop that she brought to the fire station to use during downtime. The summary judgment record indicates that both individuals, Mr. Elliott and Mr. Barrientos, Chief Elliott and Captain Barrientos, watched this video multiple times. The evidence also—
She didn't know about any of this.
She did not know any about this at the time. That's correct, Judge Ho.
What do we do with that fact?
So that fact is not—
Where I'm going with this is obviously a horrible intrusion of privacy, and I can imagine any number of legal theories that she could pursue. The question is, does Title VII cover this?
Correct, Your Honor, and the contemporaneous awareness issue, the fact that she didn't know about this while it was happening, does not matter for this court's analysis. And here's why. Under Harris versus forklift systems, the Supreme Court has made clear that a hostile work environment has to be objective and subjectively hostile. So at some point in time, Ms. Abbt does have to experience subjectively a hostile work environment. But there's no requirement that she subjectively experience this at the same time it's happening. And if you take a run-of-the-mill hostile work environment case, you can see this happening all the time. So a boss—
What if I know she discovered this, 10 years after it was first taken?
Correct.
And we're to assume that it was watched during this entire period. What if she had been retired at the time that she discovered?
She would not have a claim, Your Honor.
She would not have a claim.
She would not have a claim. And under Harris, that's because she never subjectively experienced a hostile work environment while working. So there has to be a line at which a person is not subjectively experiencing a hostile work environment, and that line makes sense to draw once the person is no longer working there, because at that point they never experienced a hostile work environment while employed. So if she had already retired, if she had already quit, and she learns about this later, she never subjectively experienced a hostile work environment. But that's not what happened.
What made it a hostile work environment once she discovered it?
I'm sorry, could you repeat?
What made it a hostile work environment once she discovered it? Does she allege that they were going to do new videotapes, or what's the ongoing?
No, the hostile work environment, and looking at what makes the work environment abusive or hostile that changes the conditions of her employment, is simply the fact that she is now in a situation where, as a condition of her employment, to go back and work at Station 18, she is going to be working with colleagues or superiors who have seen this video potentially. Now, at the time that she learned—
Who is she working with? I know there's Barrientos, there's Elliott.
Correct.
Who is she having to work with
So,
after?
At the time that she learns the video, she is not working directly with Barrientos anymore. He's been moved to a different station. The record reflects, though, that he moved to different stations frequently. So he had already been at 3 different stations and back to Station 18 previously. And so while she may not be going to the fire station and seeing Barrientos the next day, the record shows that he could have been transferred back to Station 18 at any time, and District Chief Elliott was still a district chief at that time over her station.
Okay, so the hostility of the environment was the risk that one of these people who had violated her privacy would come back, and
Correct.
she'd have to interact with them.
With Chief Elliott, he was still actually a district chief. So he was still under her at the time. I'm sorry, she was still under him at the time.
Okay, all right. And you're saying Barrientos was not, but could come back?
Correct.
And you say he was the district chief. Was he at the fire station where she worked?
He was not. So he oversees multiple stations and he travels. So the district chief is actually the only person who has a position in higher management that will actually go out to these stations. Otherwise, they're somewhat isolated, and that's something that's come up in this court's precedent dealing with hostile work environment claims in situations like this with the Houston Police Department previously. And so the district chief is actually one of the only people— this gets a little bit into the city's awareness of these issues— he's the only one outside of the fire station who's actually going to be able to get this knowledge and potentially do something with it. And that right there is really the hook for the city's liability in this case, because when Captain Barrientos shares the video with Chief Elliott, Chief Elliott is a supervisor under this court's precedents in Williamson that imputes the city with knowledge. And rather than doing anything about it, Chief Elliott told Captain Barrientos to keep it secret, followed up with a phone call later demanding access to Barrientos' Hotmail account so he could continue viewing the video on his own. And then years later, called Barrientos back again wanting an updated password. And that piece of record evidence suggests that Chief Elliott was viewing this video over time because he wanted continued access when he didn't have it anymore. And at that point, Barrientos forwarded the video to Chief Elliott. And so what we have here is almost worse than the situation in Williamson, where the person who was charged with notice, Bozeman, didn't participate in.
Do you know if or how many other people Elliott shared the video with?
The record does not reveal that, Your Honor, and that really is because the OIG investigation did not ask these individuals who else might have knowledge of the video. What the OIG simply did was confirm the charges that Ms. Abbt brought against Chief Elliott, Captain Barrientos, and Jonathan Sergio.
You've not done any discovery.
I'm sorry?
You've not done any discovery.
We have done discovery, and so through discovery, Captain Barrientos and Sorrentino have said that they did not share it with anyone else. Chief Elliott was not deposed. We do not know what Chief Elliott did with the video. That is not in the record. And
But Elliott is the one who called Barrientos and said, send it to me.
correct. Elliott is the one who received the email forwarded from Barrientos. And interestingly enough, Captain Barrientos actually deleted the original email he claims that he received with the video once he learned the OIG was going to be investigating. He told counsel in his deposition, though, he didn't remember deleting the forwarded email. And so this is another area where the OIG appeared to do no.
On their work computer, the government computer?
So with Chief Elliott, we don't know. With Captain Barrientos, he testified in his deposition that when he showed the video to Chief Elliott was at work on either Captain Barrientos' work computer or a non-City of Houston computer that stayed at the station that various people would use to print things. And so it was accessed and viewed on a computer in the workplace originally, and then moving forward where it went after that, the OIG didn't really flesh that out, and that really gets to why Ms. Abbt had such a problem with returning to work, because she didn't know the extent of the distribution of the video. And Chief Elliott here really is where the city has failed to explain any basis for affirmance. So the city didn't disagree with our analysis of Williamson. The city has not argued in its brief that Williamson is wrongfully decided, and this case fits squarely within Williamson. The supervisor in Williamson, Bozeman, had a reporting obligation. He had remedial authority over the harasser. And this court also noted in Williamson that the policy actually directed employees to go to their superior with an issue, which is what had happened in Bozeman. And here we have all of the same facts. And so when Barrientos shares the video with Elliott, the city is on notice. And the city, Elliott did nothing with it for years, and that is attributed to the city.
So I take it sounds like your theory is it's hostile because they weren't fired, and therefore there's a risk that she has to continue to work with these people.
Yes, and
Where in the record, if there is anything in the record about this notion that Barrientos wasn't there at that time, but could have theoretically rotated back at some point?
so, Your Honor, in Barrientos' his deposition, at record site 227, there's discussion of the various stations that he was at over time. He says, and for context, he's now talking about the later conversation. I'm sorry, 1 second. No, he's talking about when he received the 48-hour notice. So in 227, Barrientos is discussing where he was when the OIG investigation started. At that point, he was not at Station 18. He said, though, he had been at Station 61 in about 2012. Then he went to Station 46 for 2.5 years. Then he went to Station 61 and back to Station 18. So there's quite a lot of movement. And the record reflects that the city, through the OIG, never told Barrientos or Sorrentino not to interact with Ms. Abbt anymore, or that they wouldn't be assigned to the same stations as her. And they also never told that to Ms. Abbt.
Where is that?
And that, Your Honor, is at, I believe it's record 190 and 250.
And that's that these individuals were never told not to interact with.
And neither was Ms. Abbt. She was also not told that they would not be interacting with her.
Do I understand Elliott subsequently retired, but where is there in the record that that was after? Is there anything in the record that makes clear that she's under Elliott's supervision after she discovered?
Not explicitly, Your Honor. I'd say it's implicit in the record that he was the district chief. From the record, there's no indication that he has any other job until he retired.
Does the record reflect his retirement?
Yes, it reflects that he retired, I think simultaneously with the OIG confirming the complaint against him, but I'm answering that question from memory, so if I'm incorrect there, my apologies. And I think the hostile work environment too, even if this court is thinking, well, she finds out she's coming back to work, she's not going to have to interact with Barrientos immediately, Chief Elliott's retiring shortly after, where is the hostility? I think it's important that there was no investigation into the distribution of the video, and that's really what was animating her concern, and that in and of itself could constitute a hostile work environment. So in some of the lower court cases that we've cited, the employer, through a supervisor or another employee, actually went and asked people, who did you send this to? Who else has seen this, to try to understand, how far things went. That just didn't happen here. And so for Ms. Abbt, even if she learns about this and Barrientos and Elliott are immediately terminated, but the city does nothing else to try to figure out who else saw the video, that could still constitute a hostile work environment, especially in this case where there's evidence that it was...
You say that still constitutes hostile work. What's the that?
The that would be facing a workplace where she does not know who has viewed this intimate video of her. And in particular, Your Honors, I think the fact that what we know it was viewed at a computer at this station, and there's record evidence suggests it was stolen off her laptop from this station too. So the workplace itself has hostility to it as well, even if the two individuals who we know were involved are no longer present.
Can I ask a question?
Yes.
The problem with the psychologist, I'm not sure I understand exactly what that, I don't, first place, if you have a psychologist who's an employee of the city, I guess it's the city, grand employer, Uber Alice, you put that psychologist in a situation by virtue of her employment where she is going to be dealing with people who come to her with problems like this one, hopefully not this one, but something, why is it a problem that the city went to her and said, you really ought not to be counseling this person, even though that seems to be your job description, but you shouldn't be doing it because this is a situation in which the city is going to be adverse to her, and you're a city employee, and I think professionally there's a real question whether a psychologist under those circumstances should be consulting with the employee. So what is your client's problem with what they said to the psychologist? I think anytime an employer has a professional psychologist on the staff to, in effect, work with employees, you're liable to get a situation, hopefully not like this, but where the interests of the city and the employee are adverse to one another, and the psychologist is an employee of the city, and you wonder how can you do that if you're a professional psychologist? What is, from your standpoint, what's the problem?
Your Honor, our client's problem with that was that the city directed her to Dr. Tran as someone that could be a resource for her, and then in our client's experience and perspective, the city took that person away, or was trying to take that person away once she filed the EEOC charge. And Dr. Tran's notes reflect that after she talked to other therapists, there was no conflict, and it would have actually been unethical for her to continue seeing Abbt. And The record on this is a little confusing, but as I understand the city's argument, it's not that the therapist would then be advocating for the city once Ms. Abbt filed this EEOC charge. It's that the city, through the sort of Civil Service Commission process, might be questioning the therapist or pressing her about why she thought Ms. Abbt had PTSD, and perhaps there would be some discomfort on the therapist's part. The city hasn't explained why there's a conflict of interest on the therapist's part because
There is. I mean, there's a flat, anytime you have an outfit like the city that employs a psychologist, and the theory is that employees with personal problems can come talk to the psychologist. Well, if the personal problems happen to consist of something that's in effect adverse to the city, there's a problem, all right. Then that's inherent in the setup where the employer hires a psychologist to help employees. So I have to say I don't exactly get, and I don't understand how you could do it to begin with, but how this.
And I think then, Your Honor, Ms. Abbtt's response would be that if the city wants to provide mental health services, then those need to be separate and distinct from whoever will be reviewing her for Civil Service Commission hearings. And that's what actually happened here. A different psychiatrist evaluated her, so Dr. Train wasn't even involved in that. And I don't know why the city has it set up that they would ever go to the counselor that they originally direct employees to in that situation.
You set up something like that, Murphy's Law will work. You know?
And I see my time is up. If the court will indulge me, I just wanted to clarify something from Judge Ho's question.
Very briefly.
I cannot recall from the record when Chief Elliott retired. I know that he retired before serving his suspension, but I can't recall the exact time. So the city may be able to.
But it was after she
That is my recollection.
found out about
Yes.
the video.
Thank you, counsel. Mr. Higgason?
May it please the court? Excuse me. That's much better. I'm Robert Higgason for the City of Houston, and first I'd like to respond to Judge King's comment. There is a legitimate business reason that the city had to ask Dr. Tran, or to consider whether she should continue treating.
Oh,
Absolutely.
yeah. I mean, I don't quarrel with that. I mean, it's a problem that the city created, okay, by having a psychologist in that employment, but.
Well, it's certainly somebody that could come around to someone's problem that they go to see a city-employed counselor. It could be the problem that comes from the city. And so perhaps there should be some other mechanism in place. Generally speaking, the city's employee assistance program is to help them deal with whatever kind of things are going on. And there are many, many things other than complaints about the city that they can deal with.
Right, I understand that.
Judge Ho, you were asking about this arrangement with Elliott. Let me speak about Elliott specifically and his position in all of this. The appellant's brief repeatedly refers to him as Chief Elliott, and while that's accurate, it's not precise. He was a district chief. There are 3 levels above him to the fire chief. The hierarchy goes fire chief, assistant chief, deputy chief, then there are a number of district chiefs, and then the senior captain, junior captain, engineer, operator, and firefighter. That puts the district chief as a mid-management person, not upper management as required under Vance v. Ball State University. Now, District Chief Elliott did have a duty to report this, and he violated his duty. And in fact, he participated in the conduct, and he hid it from those who had the authority to do something about it. District Chief Elliott had a duty but no authority to remedy. He had a duty to report, violated it, and he had no authority to fix the problem. The only person who could have fix the problem is the fire chief up here at the top. And that information never got up to the fire chief to do anything about it until Ms. Abbt filed her OIG complaint and her EEOC claim. For 10 years, no one mentioned this video. And the way she found out about it 10 years later is from her husband after District Chief Elliott told her husband this is all so disturbing that people do this, that anybody behaves this way. And this should never have happened, of course, but the city doesn't sanction this. The city doesn't look the other way. The city, once it found out about it, took immediate remedial action, suspended District Chief Elliott, and he retired before he served his suspension. One might say that...
It was Elliott's job to report these issues to upper management.
Pardon me?
It was Elliott's job to report these types of issues to upper management.
Yes, Judge Hope.
Why is that not enough under Williamson?
Because he participated in it.
That makes it better?
Someone should have reported him, see. All right, he was a participant. And under this court's precedent, 1999, it doesn't cite it in my brief, maybe you don't want to consider it, but Sparks v. City of Houston, and Judge King, you were on that panel. It was the Mounted Patrol in Houston Police Department, 1999. The facts might ring a bell for you. And there was much, much more open harassment of the one and only female Mounted Patrol officer in that case. And there was, it was all very open. They were doing a lot of horrible things for the entire time that she served in that unit. And in that case, there was summary judgment granted under Title VII, which this court affirmed, and the cause went on under 1983 and found liability against the city, and this court affirmed that, and it was under retaliation for her speaking out, and it's a whole different legal analysis. But one of the important things, I mean, in fact, the facts in that, I even hate to bring it up because of so many people acting so badly, but there is a very important couple of paragraphs in there where this court held that if the supervisor is participating in the conduct and hiding it from those with the authority to fix it, then that knowledge is not imputed to the city. That's very important in this situation because we had Elliott violating his responsibilities and participating in the bad behavior and hiding it from those who could have fixed it. The city cannot be held responsible and liable for something that it didn't know about when someone close to it, let's say, in mid-management, wasn't doing what he was supposed to do, and they didn't know he wasn't doing what he was supposed to do. And once they got her OIG report and EEOC complaint, well, they dealt with all three of them. And Barrientos was demoted 2 positions from senior captain to engineer operator.
So I just want to make sure I understand. So are you saying Sparks versus City of Houston stands for the proposition that if the knowledge remains at the level of a mid-manager and is not shared with anyone in upper management, then the city has no liability? Is that what it stands for?
Judge Graves, I would like for it to mean that. I'm not certain it goes quite that far. That's the reason I'm bringing it up, but I want to not rest solely on that. It's a couple of paragraphs in there discussing this, and then going on to discuss constructive notice, and that's what that case turned on. And one might consider that dicta, so that's why I don't want to say it absolutely stands for that proposition, okay? And so you could say that, but if you look at the cases that Sparks cites, then it has, which are Walton and Nash, those also get us to that point. And I would like to say that that's what that case stood for, but that's not really what that case stood for. It does that in passing to get to where it's going.
But it's the best one you get.
Well, it's an important point. I think the best point that we have is that Vance v. Ball State University talks about, for purposes of liability, vicarious liability under Title VII, the person with the knowledge has to be someone who has the ability to do something about it, to remedy it. And then it goes on and talks about what the remedying would be. And we've discussed this in our brief at page 14. What Vance state, the Supreme Court said that a supervisor for Title VII vicarious liability purposes is one who is empowered by the employer to take tangible employment action against the victim. District Chief Elliott is not that person. The Supreme Court defined tangible employment action as, quote, a significant change in employment status, such as hiring, firing, failing to promote, reassignment with significantly different responsibilities, or a decision causing a significant change in benefits. During this time, in fact, Melinda Abbt was promoted from firefighter to engineer operator and then to captain. In fact, she was promoted to captain while she was out on her medical leave. And so there wasn't any kind of adverse impact on her there. And the one who could have done any of those things and who approved those promotions was the fire chief. And the Supreme Court further said that the ability to direct another employee's task is simply not sufficient to warrant vicarious liability, and that's in Vance.
Okay, but just to be clear, this is an alternative theory of vicarious liability. Ms. Abbt is also arguing Williamson.
Okay. Vance is more specific than Williamson. All right, in Williamson, it says that, yes, a sergeant's knowledge could be imputed, but that was in 1998, and Vance is in 2013 from the U.S. Supreme Court and is far more specific in talking about Title VII and what it takes to be a supervisor.
I'm not sure I understand that argument. You're saying Williamson's no longer available to her?
It doesn't address the situation. Vance makes it clear that for Title VII, you have to be somebody who has the authority to do something. The only person who has the authority to do any of those things under Vance.
Right, and Williamson's about somebody having the duty to report up
Right.
to such a person.
Yes. But it doesn't, okay, yes, but it doesn't involve somebody who participated in it. And this is where the discussion...
You acknowledge then that had Mr. Elliott not participated in this, that you'd have liability under Williamson?
That would seem to be the case. If he there's this discussion...
Your theory is essentially that we'd have to carve out an exception to Williamson for when such a person is participating, and you cite Sparks for that.
Yes, Sparks. Oh, and, well, excuse me, I'll lift it over there. Okay, so, Barrientos was disciplined, Sorrentino was disciplined, none of these people were, and Elliott was disciplined and then retired. None of these people were supervisors under Title 17, and so she can't meet her Title 17 showing. That's the significance of Vance here. The idea of assuring Ms. Abbt that she would never come in contact with these firefighters again is not really enough to show that...
You say none of these people were her none of them were her supervisor, or was her supervisor?
They weren't her supervisors.
Who was her supervisor?
Under Vance, for Title VII purposes, that would be the fire chief. Now, that seems like a lot.
So her day-to-day, fire chief wasn't aware of her day-to-day operations and what she did, assignments. He wasn't aware of any of that, was he?
That's correct, Judge Graves. Now,
But he's her supervisor. So as city attorney, I guess the mayor's your supervisor.
well, for purposes of Title VII liability, that might be the case.
So it doesn't mean the person who actually supervises you.
Well, that's up to the Supreme Court of the United States to do with its definition of what it takes to be a supervisor under Title VII. It's not I'm not just kind of coming up with that. What we're talking about, Judge Graves, is you and I will use the word supervisor in a colloquial way or a common way, and Title VII uses it in a very specific way, like a term of art. And so, sure, she had people supervising or directing her daily activities, and Vance specifically speaks to that directing the daily activities of a lower employee is not enough to be a supervisor for purposes of Title VII. You know, otherwise, I agree. There are a number of supervisors around, but not Title VII supervisors. So we don't disagree with Williamson, we just say that Vance is more focused on this situation. There is this question about, I was kind of just commenting about Ms. Abbt not wanting to make sure that she would never run into any of these people again. And that's not something that the city could assure. It's not an essential remedy. Now, Elliott was gone. Sorrentino.
What do you mean that's not an essential remedy? What do you mean by that?
There's no authority that says that that's something that the city would have to do to remedy this situation. The plaintiff hasn't cited any authority to say that.
What about Cottrell in the Eighth Circuit?
I'm sorry?
Cottrell in the Eighth Circuit? Cottrell versus MFA?
Sorry. Well, it doesn't go to making sure that out of 4,000 people members of a fire department, that you make sure that this person doesn't go there. And then she decided that she didn't want to come back and wanted to work from home. And part of her complaint is that the city wouldn't create a position for her to work from home as a fire.
What if she discovered that they were watching this video 10 minutes or 10 days rather than 10 years later?
Oh, well, let's see. If she discovered it then, if the city learned about it then, you mean like if the fire chief learned about it in 10 days?
And they said, you know what, you're still going to work with these people. They're still going to be around.
I think that would be a very different situation. A very different situation. I think the fact that she hadn't worked with these people for 8 years, I believe, they weren't in the same station, and the idea that there was some chance that Barrientos might transfer back to there, like he might transfer to another station or another station or another station around the greater, around the Houston area. If that ever looked like it were happening, then that could be raised at that time. But to say, we will make sure you never encounter this person out of 4,000 in the department is just something that isn't really necessary to achieve a remedy. These people were disciplined. Over the 10 years, no one ever mentioned having seen this until this one.
Well, in Cottrell, the person was fired.
Pardon?
In Cottrell, the person was fired.
Right. Well, and
You could fire them.
And that may well have been the thing that the fire chief would have done here if he'd learned about it.
Are you saying the fire chief doesn't know about this to this day?
If he had learned about it 10 days, I was going back to your.
Yeah, but he didn't fire him after 10 years.
I'm having a little trouble with the.
I'm sorry.
Echoing.
The fire chief did not fire. We have this case. This is not a counterfactual. We have the actual case. These people were not fired. They were disciplined.
Right. You're asking why didn't the fire chief fire them?
Right.
That's.
You're making it sound like the fire chief couldn't fire him. That's
Oh, no, the fire chief, of course, could fire them.
right. He just decided not to.
He decided not to. And we don't have the information for all of that in the record. But that's in the.
And you don't dispute that Elliott was under her, how do I say this? Elliott is in the line of command over Ms. Abbt.
I don't dispute that. Yes.
You know when he retired? Or when he left being over her?
I do not, but since from the time that she reported it and the discipline was investigated and the conduct was investigated rather, and he was disciplined and then he retired before serving the discipline, this is a fairly short time frame, and then, her filing the suit. So, no, I don't.
When you say fairly short time frame, what do you?
Well, we're talking
days, a
17
few months.
No, it would have been a matter of months, but I don't think that it's in the record how quickly he was gone. And Sorrentino was elsewhere. Barrientos was demoted. They were both elsewhere. She was, in fact, during this whole time period that she worked there, she was promoted twice, so 2 levels up. There was no action taken against her.
Why is that relevant? It's a hostile work environment claim, not an adverse employment.
Well, sure. It's just kind of a picture of all of this. She ended up at a higher position, and Barrientos ended up at a lower position. He was disciplined enough, so much so, that she ended up at a higher position than he was. And no, it's not legally relevant, Your Honor. Since neither District Chief Elliott nor Captain Barrientos were her supervisor for Title VII purposes, Ms. Abbt cannot make her claim. As a matter of law, she can't meet the requirements of Title VII liability. As far as a hostile work environment goes, there was nothing hostile about it until...
Why should it matter that she discovered it 10 years later rather than 10 days or 10 months? If I heard you correctly earlier, if you discover that somebody's invaded your privacy this way, there's somebody who's in some level of supervision over you, and you have to continue, you have the risk of continuing to be exposed to them going forward. If it's 10 days later or 10 months later, I think you said that would be a different case.
Well,
why does 10 years make a difference? Why does the time make a difference?
I think that as a practical matter...
Why isn't it worse? It's been happening for 10 years.
Okay. People are different people. There are different employees around. People are at different places in this very large department that's scattered across a very large area. Some of them are not there anymore. These three men were still there. One of them then left soon. But they were...
Why isn't that a jury question, though? I mean, ultimately, it's, you know, how much of a risk, how much of a fear, how hostile this environment might be to the reasonable person. Why isn't that all for the jury?
Well, because she...
You are asking us to declare as a matter of law
Yes.
that this is not a hostile work environment. Vicarious liability as well, but you're also saying it's not a hostile work environment, I think.
I think it's a problem. I think it's a problem. I'll say that. But I don't think that it meets hostile work environment. Nobody treated her any differently during all this time. And so once she finds it, she never went back to work once she learned about it. And so she doesn't really have any evidence that there was anything.
You're not saying it's her fault.
Pardon me?
You're not saying this is fraudulent. I mean, she's clearly reacting to this event, right?
No, I'm not suggesting
Okay.
that it's fraudulent. She's reacting to it.
So I'm not sure I understand your argument.
Okay, she reacted to something that to her was humiliating, embarrassing, traumatizing, whatever we want to say. I'm not disputing that. But then she wasn't ever back in the workplace. And so there was nothing happening then in the workplace that was hostile. There was this event from 10 years earlier.
Do you dispute that she's leaving the workplace to avoid this, what she perceives anyway as a hostile environment?
Yes, I think she was staying away to avoid what she perceived as a hostile environment. Yes, Your Honor. I think that there wasn't anything objectively hostile about it. They did some very bad behavior 10 years before, and during that entire time, they never treated her differently, and she admitted that.
All right. So your position is it's not objectively.
Exactly.
It is clearly subjective.
Oh, yes.
You acknowledge that. It's just that it's not objectively hostile.
That's right, Your Honor. Thank you. Thank you.
Thank you, Counsel.
Thank you, Judge.
Rebuttal.
Thank you, Your Honor. I just want to clarify, Ms. Abbtt's claim under Williamson is holding the city liable for negligence. Vance is about the city's liability under a theory of vicarious liability, and that's why the supervisor test is higher. And this came up in Williamson. Williamson was a negligence case, not a case under Vance. Vance hadn't been decided yet, but the Farraher-Ellerth defense had been laid out by the Supreme Court, and this court noted that affirmative defense wasn't relevant for Williamson because Williamson was a negligence case. And so the Vance supervisor test doesn't have anything to do with Williamson. Williamson sets its own test about what level of person can put the city on notice. And so the city's attempt to import the Vance supervisor test into Williamson is without basis. The second point I'd like to make is that the city's argument is essentially that the only reason Williamson does not apply here is because Chief Elliott joined in on the harassment. And that has very problematic implications because what it means is that by carving out this situation from Williamson, the result of that holding is that so long as every person up a hierarchy who learns of the harassment joins in on it, then the employer is not on notice. There's no limiting principle there. So under the city's argument, as I understand it, if the fire chief had notice of this and then joined in on the harassment, the city would still be not on notice under Williamson. That argument does not make sense. I'll speak briefly on the case.
Can you address, you may be going there, Sparks?
Yes, I think it might be Sharp versus City of Houston that the council's referring to. And in Sharp, we have a lieutenant and 2 sergeants that were involved. One of the sergeants and one of the lieutenants were the harassers. The court held that there was constructive knowledge in that case, not actual knowledge that we have here. And the court noted that the sergeant who was underneath the lieutenant, the one who was not harassing, he could not serve as the person who was on notice to impute the city with notice because he was below the lieutenant. He was below one of the harassers, so he had no remedial authority. This court said in a footnote, it's footnote 9, that it was leaving for another day whether there was notice because the lieutenant who participated in the harassment also had notice of the other sergeant's harassment. So the situation we have here, whether there's a mid-level, Captain Barrientos, and someone above him who then joins in on the harassment, this court left that situation for another day in Sharp. Sharp does not address this situation. That's footnote 9, so I'd ask the court to look at that when looking at Sharp. So Sharp did not decide this.
It's not even dicta.
It's not. It was left for another day.
Identified fact pattern that's not addressed.
That's correct, Judge Ho. And then the last point I'll make, I heard Judge Ho ask some questions about Cottrell out of the 8th Circuit. I know in that peeping, it was a peephole case, the fact that she was not aware of the peeping while it occurred led the court to decide that it wasn't hostile. I think it's important in that case that she then chose to go back into that environment to help catch the perpetrator.
In fact, the perpetrator was removed.
Correct.
Whereas here you're saying they're not removed.
Correct. And then the only other thing I'd mention about Cottrell is the cases that were actually cited when the 8th Circuit noted that she didn't subjectively perceive the peeping, so it wasn't hostile. Those cases actually are about when someone can rely on a harassment of other people to support a hostile work environment. And some of them, one of which, Harass Doy out of the 10th Circuit, actually allowed someone to offer evidence of harassment that occurred to another person that person then told the plaintiff about. And so that's an example of the plaintiff did not perceive that harassment. The plaintiff learned about it later, was directed at someone else, and the court still allowed that as evidence of a hostile work environment. And so this Harass Doy case from the 10th Circuit actually supports that you don't need to immediately perceive harassment for it to be hostile. And I'll yield the rest of my time unless there are other questions.
Thank you, Counsel.
Thank you.
Court will take this matter under advisement, and that concludes the